Florida.
Jennifer Garcia for the state of Florida.
And defense, Catherine Conlon, along with Andrew Parnell, we represent Ms. Redlick, who's present.
My understanding is that we have a verdict, so let's bring in the jury, please. Okay, ladies and gentlemen, my understanding is that you have reached a verdict. Is that correct? Yes. Okay, would you please hand the verdict forms to the deputy, please?
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, case number 2019 CF 18460, State of Florida versus Danielle Justine Redlick. Verdict as to count 1, we the jury find the defendant not guilty. So say we all. Signed, juror badge number 283, foreperson. Special finding, this page was left blank. Verdict as to count 2, we the jury find the defendant guilty of tampering with physical evidence as charged in the information. So say we all. Signed, juror badge number 283, foreperson, dated at Orlando, Orange County, Florida on the 17th day of June, 2022.
And would you please poll the jury?
Yes, ma'am. Juror badge number 283, are these your true and correct verdicts? Juror badge number 18, are these your true and correct verdicts? Juror badge number 220, are these your true and correct verdicts? Juror badge number 238, are these your true and correct verdicts? Juror badge number 356, are these your true and correct verdicts? And juror badge number 5345, are these your true and correct verdicts?
Yes, ma'am.
Thank you.
Ladies and gentlemen, I wish to thank you for your time and your consideration of this case. No juror can ever be required to talk about its discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that a jury's deliberations, its discussions, and its votes should remain their private affair as long as they wish it. So, the law gives you a unique privilege not to speak about the jury's work. And although you are at liberty to speak with anyone about your deliberations, you are also at liberty not to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And so on behalf of the Chief Judge of this circuit, Chief Judge Lisa Munyon, I want to thank all of you for the 2 weeks that you have spent with us in serving your civic duty and serving as a juror on this case. Your duties are now discharged and you are excused. Have a wonderful day. Take care. You're welcome, sir.
Thank you.
Ms. Redlick, a judgment of acquittal will be entered for you on counts number 1. A judgment adjudicating you guilty is entered on count number 2. State, is there any legal reason we cannot proceed to sentencing today?
Yes, Your Honor, she's entitled to a PSI, but also want a chance for any sort of impact testimony to be offered. So that's why.
Okay. I will ask Mr. Parnell, who's standing. She is entitled to the PSI. Do you wish to waive the PSI and go forward with sentencing, or do you want to have a PSI ordered, and I will set sentencing off?
If we end up setting sentencing off, then I would be asking for her release, because at this point, she's going to score 16 points. Jury has not made a finding that would allow for the court to sentence her to prison. Her credit at this point is 3.5 years, and I don't want her sitting in jail longer, which would essentially be adding and extending a prison sentence. So if we want to go ahead today, I understand victim impact, they have a right to do that. So if we set it off, then I'd be asking for the court to release her and set the sentencing date in the future.
Mr. Wiggins, state's position?
Or the state would like to explore the possibility of the imposition of an upward departure, and so I don't believe that would be necessary at this time.
Okay, so I will set sentencing off. Let me set sentencing for August 5th at 10 o'clock. And I'll have that set. I think an hour should be sufficient for that. Betsy, can I have a calendar for August? Can we have a calendar for? Any sentencing memoranda that the parties intend to file for the court's consideration need to be filed by July 15th, close of business on that day. Was there a bond on count number 2? Or I believe proof evident presumption great was found on count number 1. What was the bond on count number 2?
I don't know, Your Honor.
I don't. Okay, so the bond on count number 5, she has a bond, it's raised to $15,000, that's always been in place.
Judge, may I approach with case law?
Sure.
This is not, this is. Position that in order to sentence her above essentially a county jail sentence, if she does not score 22 points on the score sheet, which I believe we should be around 16.2 here, then the jury would have to make a finding as to her dangerousness. That has not been found by the jury. And so I think a sentence above time served or potentially probation would be unlawful, and that therefore every day she spends in jail awaiting that, whether she has a bond or not, would also be unlawful.
It doesn't appear from my cursory review that the Brown case speaks directly on your point regarding the fact that this defendant here has a bond in place right now, that there isn't a finding that the court is holding her. She has been granted a bond pursuant to Florida statute. Help me understand more about how Brown
As to the
is
bond,
applicable in this case.
As to the bond issue, I don't think it touches on that. I think what we're getting at is that whenever she is sentenced,
Okay,
it cannot be to higher than the days she has already served, that she has credit for time served.
okay.
And keeping her in jail until that date is essentially holding her to what we know she cannot be sentenced to. It's time that she can't get.
Okay. I don't find that Brown is applicable in this particular situation. I'm not sentencing her today. I'm setting sentencing off for August 5th. She has a bond in place. She can make bond and she will be released. I'm not changing the conditions of her bond. So your motion for me to release her today will be denied. Anything further from the state that I need to take up?
No, Your Honor.
Defense.
Don't think so.
Okay.
We'll write a motion if we need to.
All right, sounds good. All right, so we are adjourned. Everyone have a good day and be safe.